Before I get started, I want to do just a couple housekeeping things. First of all, for those of you who have not yet been on one of our webinars, welcome. Thank you for joining us today. And in front of you, the bulk of your screen really should just be the PowerPoint presentation. And then you will see kind of on the top left, sorry, I don't know right or left today, on the top left corner, you should see hopefully a very small video of me talking, but you can pay no attention to that. Let's just look at the PowerPoint and you'll be all good. And on the bottom left-hand side is a little chat box where if you have any questions as we're going through, you would go down to where it says type here, and you could type your question in, and it'll appear here on my computer as well, so I'll see it. And I'm going to save all the questions for the very end of the presentation, so if I don't immediately respond to your question, don't retype it. I have it. I'm just saving all the questions for the end. So with that in mind, oh, one more thing. Credits. The credits for this presentation, they will be automatically generated and emailed to you within a day or two of the webinar. So there's nothing else you need to do other than be signed in and stay signed in for the entire presentation. Okay, I think maybe I am ready to move on. How about you guys? Here we go. Okay, so no class or webinar that Elina Gilbert teaches would be complete without silly, goofy comics throughout the presentation. Make sure everyone's paying attention and gets a good chuckle. So this is the first one, and they all have to do with meetings. All right, poor chicken, but let's move on and talk about some substantive stuff. All right. Let's first, before we even get to executive sessions, let's talk a little bit about board meetings in general. And the fact that all board meetings are open. What does that mean? It means they're open to attendance by who? Owners or their designated representatives. So what is a designated representative? Well, it's anybody, it doesn't have to be another homeowner, but it's anybody who essentially has been designated in writing. Kiowa says it has to be in writing as the representative for a particular homeowner. Now notice it's owners, and then there's capital letters or their designated representatives, which means if a homeowner shows up with someone who they have made their designated representative and the association wants to be somewhat snotty, it can absolutely say, hey, it's one or the other. You both can't be in here. And we kind of have seen this more and more with attorneys. So a homeowner will show up at a meeting and they have an attorney, and the board isn't very comfortable with that. So they say, hey, it's one or the other, and the homeowner leaves and the attorney stays. That's not the result we really want. The only other thing I can tell you is if an attorney shows up and says, I am the designated representative for this homeowner, the association, the board is well within its rights to say, we need to see the piece of paper where you are so designated as the representative. And that's not just an attorney, it could be anyone. It's any person who says, I am here on behalf of Joe, in Unit 3. The board certainly can ask for a copy of the designation in writing, and if that person doesn't have the designation, they do not have to be let into the meeting. Now, one more thing about the actual designation, and that is there's no specific form it has to take. Someone could really write it down on a napkin and say, I designate Bob, the attorney, as my designated representative for the purposes of this meeting, and we have to let them in. Okay, so that's what it means to have an open board meeting. It means homeowners or their representatives can attend, and we can't kick them out. Why are board meetings open in general? Well, as you guys know, there has been a push towards transparency for quite a while now, and I think rightfully so. Obviously, homeowners are the ones who pay the assessments, and it's those assessments that really pay for everything that the community does. And as a result, certainly homeowners are entitled to know what is going on within the community that they're paying towards, and what the boards are doing and what is being discussed. So it makes perfect sense that board meetings be open to homeowners, because there really shouldn't be any secrets. So that's why we have open board meetings, obviously, because Kiowa says they have to be open, and so does the Nonprofit Act. Okay, so then what are executive sessions? Executive sessions, much to most people's dismay, are actually part of a board meeting. I have been to many a board meeting where the boards will have the executive session before they actually call a meeting to order. They're like, well, it's an executive session, so we're going to have it first. Well, the truth of the matter is, an executive session is just a portion of a regular or special board meeting in which people are excluded. It's still part of the board meeting. Okay, so best practices would be not to have the executive session and then call the meeting to order when you're done, but to actually call the meeting to order and then go into executive session. Because the statute says executive session is truly part of the board meeting. So it's part of the board meeting, but it is an exception to the open meeting requirement we just talked about, right? So that means we can exclude people from being in that portion of the meeting. So let's move on. Oh, wait, okay. So speaking of excluding people, you guys ever been to a board meeting like this? Where the board's like, yeah, I know what you're talking about. You know, that thing we talked about before. Oh, yeah, I know. And then the homeowners are sitting there going, we have no idea what's going on here. Clearly, there's been some kind of a discussion outside the meeting, right? All right. So let's talk a little bit about the process. If we're saying that an executive session is part of an actual meeting, what is the process that has to be utilized for a board that is going into executive session? And remember, I said, you know, if the executive session is the first part of the board meeting, still call the board meeting to order. So the next step would be is an announcement has to be made. And by the way, this is something that Kiowa does require. So I'm not just making this up, and this isn't necessarily best practices, even though it is, but it's also statutorily dictated. So an announcement is made that the board is going into executive session and the time. So the meeting is called to order at 7 p.m. At 7:01 p.m., the board goes into executive session. And what's the general subject matter that's going to be discussed? Well, it could be something really, really broad. In fact, it should be very broad. For example, board goes into executive session to discuss legal advice. Period. End of story. That's all you have to say. You don't have to say what the legal advice pertains to. Board's just going into executive session to discuss legal advice or to discuss pending litigation. Board is going into executive session to talk about employment issues. So it really just needs to be a very broad statement without disclosing any of the items that are really meant for executive session. So then the time you went in, the general subject matter, and then the only other thing is the time that you come out. And obviously, when you come out of the executive session, you don't have to formally make that announcement to the homeowners other than to say, hey, you guys can come back into the room if that's what you're doing. But as far as the minutes go for your regular board meeting, you need to have the minutes specify what time the board went into executive session, the general subject matter of the executive session, and the time the board came out of executive session. Now, I know some of you are probably wondering whether you should be taking minutes while you're in executive session, and we will talk about this, but later on in the presentation. But for now, the only thing I want you guys to be aware of is the actual process for going in and coming out of the executive session and what the regular meeting minutes need to reflect. So hopefully that makes sense. If not, feel free to type a question down in the chat box. So before we get into the nitty-gritty of the appropriate reasons to go into executive session, let's talk about a couple other things. Why do we need executive sessions? Well, part of it, I think, is self-explanatory based on when we talk about the actual reasons we go into executive session. But I think the overarching idea with executive sessions is, yeah, there are going to be some things that are either embarrassing or are attorney-client privileged or privileged in some other ways that would be detrimental for an association if the board talked about it in an open meeting. Okay, and this will make more sense as we start talking about kind of the reasons for executive session. But ultimately, the executive session exclusion to open meetings is really legislature's way of recognizing that, okay, yes, meetings should be open, but there are certain things that homeowners should not be privy to, okay? And so that lends the question of, well, who can we kick out as a board? We can kick out anyone we want, other than other board members. You can't really exclude other board members from an executive session. But you know what? Hold on one second. It looks like my phone keeps. Can you guys hear this phone ringing? Let me put it on D&D really quick. My apologies for that. I had forgot to turn off the ringer, so sorry. But anyway, so who can be excluded? Anyone other than a board member. So the manager can be excluded. Homeowners can be excluded. Guests can be excluded. And by the same token, the question that kind of comes up, piggybacking on that one, is, well, who can we allow into executive session? Is it only the board, or can we allow other individuals in there? And the answer is you can allow other individuals to be part of the executive session. The point of the executive session is for the board to talk about or meet with whoever it is that's necessary for the point of the discussion. So again, we can say, all right, so we're going to go into executive session. The homeowners are excluded, managers excluded, but we want these two committee members in because we're going to talk about something related to their committee. Certainly that is acceptable. So an executive session does not necessarily mean that it's just the board, okay? So keep that in mind. Executive sessions can be tailored to include whoever we need included as part of the topic of discussion. All right. How true is this? All right. So now let's get down to the nitty-gritty and talk about really the acceptable reasons for going into executive session. Now, I want you guys to keep in mind there are 6 reasons we're going to talk about, and they're all contained in Kiowa. And if the topic of conversation is not one of these 6 reasons, doesn't fall under any of these reasons, it has to be discussed in an open session, even if the board doesn't want to. And all too often, I've been to meetings where boards still go into executive session to talk about something that really doesn't fall within any of these reasons. So like I said, Kiowa has 6 very specific reasons for associations and boards to go into executive session. So the first one is, it's actually it's one section of Kiowa, but I think it's got like 3 different things in there. So if we're talking about employment matters, that's 1. If we're talking about the management contract, that's 2. And then discipline or dismissal of an officer, agent, or employee. So dismissal of an employee falls under, I think, employment matters. But the discipline or dismissal of an officer or agent, who are the officers? It's the president, vice president, secretary, treasurer. Those are the 4 typical officer positions. Now, dismissal of an officer, let's be clear, that just means we say, Bob, the board is voting on dismissing you as the board president. Okay, you're now a member at large. It doesn't mean we dismiss someone as a board member. They still stay a board member. We are just going to vote on removing you as board president. Now, if we're going to do that, it is appropriate to do that in an executive session if we want to. We don't have to. It's just an appropriate reason. So again, if we're going to remove someone from their office as president, vice president, secretary, treasurer, then we can do that in an executive session. Removal of or dismissal of an agent. That one's a little bit more confusing because an agent really is, or it can be any contractor, any like the managing agent, so the manager, employees, but employees are employment matters. So this, I don't think it's completely clear what we mean by dismissal of an agent, but I ultimately think it is going to be either the managing agent that they're talking about or some other agent representative of the association. So, and then employment matters, I think those speak for themselves. Employment matters are matters where the association actually employs somebody. It's not an issue where we have a landscaping contractor who isn't doing their job and we want to cancel the contract. That's not an employee-employer relationship. That is a situation where we have an independent contractor that the association has contracted with to do a certain job. So that's not an employment matter. An employment matter truly is someone you're going to give a W-9 to. So again, be careful as to what you include in this. It really has to be someone who is employed by the association to fall under this first reason to go into executive session. All right, number 2, a lot easier to explain. Consultation with legal counsel. Okay, so the attorney is there at the meeting and we're going into executive session to talk to the attorney about, what are we talking to the attorney about? It has to be related to legal issues, pending litigation, anything that's legal in nature. If you're just going into executive session to talk to the attorney about, hey, tell us more about, you know, your firm and the attorneys who work at your firm and what your firm does, that is not attorney-client privilege communication. That is something that would be done in an open session because you're not talking about any pending litigation or legal issues. You're talking about the attorney's firm and what the firm does. It's really nothing more than a contractor discussion because an attorney is still an independent contractor for the association. Okay. Next, criminal misconduct and investigation. One thing I want to make very clear on this is it doesn't matter who the investigation is targeting. In other words, it doesn't have to be just a board member. It doesn't have to be a an officer, doesn't have to be an employee. It could be anybody. So let me give you an example of a real case. I don't believe it's out of Colorado, but it really doesn't matter. This is a real situation that happened where a community got wind of a sex offender list, which you can pull up almost anywhere, and they saw that John Smith, and I'm making this name up, it's not a real name, John Smith was a registered sex offender. And John Smith lived in the community, and the board went nuts. And in an open meeting, the board announced to the homeowners that, oh my God, John Smith is a registered sex offender who lives at this address. This is, what he is, a registered sex offender for. This is awful. This is horrible. And they proceeded to have this discussion. Now, the board was under the impression that, well, hey, we know this is true because we have the registered sex offender list. We see John Smith on here. And so we're not going to get in trouble for this. Well, the next meeting, first of all, after that meeting, a lot of homeowners started reaching out to John Smith, and it wasn't very nice. And so John Smith came to the next board meeting and he said, I'm not a registered sex offender. That is not accurate information, and you guys need to not only stop doing this, but you got to let homeowners know that I'm not a that I'm not a registered sex offender. And the board ignored John Smith because they had their list, and they kept making that representation, kept talking about it in open meetings. John Smith asked them one more time to stop, and guess what? They continued on. Well, as it turns out, the registered sex offender was John A. Smith. The guy living in the community was John C. Smith. Oops. Guess what? John C. Smith sued the association and got a lot of money for what the board had done. So even though the board was convinced that they were protected by the fact that they were talking about the truth, they were wrong. And they were not protected because this was not the right John Smith, and they were talking about criminal misconduct. Again, be very careful. You should absolutely go into executive session if you're talking about any criminal misconduct, anybody, okay, or any investigation. All right, I think we nailed that one down. All right, and then come the next 3 reasons, and these 3 reasons are, well, these 2 of them, 4 and 6, are a little bit problematic, especially 6, so that's why I saved it for last. So 4, protected communications. What does that mean? What it means is it's communications that are protected by legal or statutory rights, okay? So it's not just, oh, I deem, as the board member, this communication protected, and therefore this is going to be an executive session. That's not what this is. So protected communications, there's very few really. So one is the attorney-client privilege, and we've already addressed that, and we're going to address it again in number 5. The only other really protected communications would be if the association has medical information with respect to a particular homeowner. Why would we have medical information is the question I normally get. Well, maybe we have a disabled individual in the community. They're asking for an accommodation. They provided us with a doctor's note that talks about their disability and the need for the accommodation. That would be a medical situation that you would never, ever, ever, ever want to disclose or give copies of to anyone else. That would be considered protected. It's a medical record, and that is not something that you would talk about in an open meeting. What other things? The one other thing that I hope your communities don't have, and if they have it, you should be wondering why they have it and kind of what they're doing with it, is credit reports. But if for some reason your boards have credit reports they're going to talk about, absolutely go into executive session for that, because that is extremely privileged information. Now, there may be a few others out there, but these are the ones that we find really apply in an HOA setting, or could apply in an HOA setting. And really, like I said, there's very few true protected communication. Okay, so number 5, again, we're back to the attorney-client privilege, and this one is the attorney is not at the actual meeting. Okay, so the first one, the attorney was there and was talking to the board. This one is the attorney is not there, but the board wants to talk about some communications it received from the attorney, whether it's written, so an opinion letter, for example, or oral, a telephone conversation that a board member had with legal counsel. Either way, if you're going to talk about that, you can go into executive session. Again, be careful, because these communications really need to be legal in nature. If you're talking to the attorney about, the firm has 15 attorneys and 3 of them are collection attorneys, that is not pertaining to any legal advice. That is not an attorney-client privilege communication. Those are the types of discussions you can certainly talk about in an open session, and you don't necessarily need to go into executive session. In fact, you should not go into executive session to talk about those types of conversations. But I think for the most part, you guys aren't calling the attorneys to talk about the weather or how their firm is doing. You're really talking about legal issues. And so I think the exceptions for this are few and far between. All right. Last but not least, invasion of privacy. This is one that gets boards in trouble time and time and time again, because this provision is used very broadly by many boards to go into executive session for things such as delinquencies, covenant violations. Those are the 2 biggies. And those are the ones that we see boards using as reasons to go into executive session time and time and time again. Now, why don't they fit under an executive session? Okay, let's talk about that. An invasion of privacy. Whose privacy are we talking about? Well, the owner's privacy, the person who we're talking about, their privacy. When does a matter become private? A lot of times it becomes private when the person says, this is a private issue, I would like privacy. They've invoked their right to privacy. So when we're talking about collections, for example, boards say, well, that's private to each owner as far as if they're delinquent, and we're not going to talk about it in an open session because it's private. Well, first of all, it's not necessarily private. Every homeowner in the community is paying towards the association funds and is entitled to ensure that their neighbors are also paying into the association funds. That being said, I'm not indicating that homeowners should all be provided with a delinquency list. That is not what I'm saying. But to the extent that the board is talking about delinquencies, you will typically have a list of the various delinquencies, and they're compiled for the board in their board packet. And that list is going to be labeled in some fashion. So delinquency number 1, delinquency number 2, A, B, C, D, account number, however you guys do it. But it is a lot easier and cleaner to say, okay, board, look at your delinquency list, look at number 1 on that list. This one is probably going to go over to the attorneys because they're 90 days delinquent and they still haven't paid. We're not talking about who the actual owner is. We're not disclosing that. We're not identifying the property with an address. And so what that allows us to do is conduct business, talk about delinquencies with the homeowners staying in the audience and being able to hear this and knowing that the board actually is doing something and is taking steps to ensure that the delinquent accounts are being collected on without identifying who the actual delinquent owners are. So again, and the problem with identifying the delinquent owners, again, isn't a privacy issue. It is a liability concern, much like John Smith, who we said was the sex offender and really wasn't. Well, the same thing with delinquent assessments is if we identify someone in public, at a board meeting as being delinquent, and then later it turns out, oh, it was an accounting error, or we didn't apply his check like we should have, or something like that, where it turns out later that they actually were not delinquent, guess what? There is a liability exposure because the board has publicly announced that this person is delinquent and they really weren't. So that's really the concern with identifying the delinquent homeowners in an open meeting. Again, it's not so much privacy as it is liability. Now, I want to make it really clear. If a homeowner comes to the board and says, hey, I know I'm delinquent and I want to come talk to you guys about it and work something out because, I've got some stuff going on and I really want to talk to you, but hey, can we do it without any other homeowners there? It's really embarrassing to me. I just want to talk to the board about it. No one else. Now, in that case, I think it is absolutely appropriate to go into an executive session because the homeowner has now invoked his or her privacy issue or their privacy concerns. So they've made it about privacy at this point, and we should honor that. And then at that point, I think it does become an appropriate topic of discussion for executive session. But short of that, if we're just talking about delinquencies or we're just talking about various violations, we really just need to refer to them by their ID number, however they're designated on the list, and still have that open discussion. Again, because the homeowners are entitled to know that the board is actively pursuing either the delinquencies or the violations in the community. So hopefully that makes sense. And hopefully, if you guys as managers are in a situation where you are at a board meeting, the board does want to go into executive session to talk about, these various issues, you can tell them, look, that's not an appropriate reason to go into executive session, and hopefully they listen to you. We know that sometimes boards are going to do what they're going to do. All right. Oh, good, we need a breather. Minutes. You guys take minutes like this? I think sometimes that's more helpful. All right. Sure, everybody had a chance to giggle. Okay. Now, what can't be done in executive sessions? When I ask this question in class, I usually get a whole bunch of people raising their hands and they say, you can't do anything in executive session. You can't make decisions. You can't take minutes. Remember, we talked about minutes earlier. Can't do anything. All you can do is discuss the issue, and then you have to come out of the executive session and make your decision once you're out in an open session. So that's actually not accurate. The boards can do anything in executive session except adopt rules. Now that's an odd one. I can't profess that I know the reason why that's the only exception to what you can do in an executive session. But that's what Kyla says. However, the caveat is whatever else you're doing in executive session outside of adopting rules, it still has to fall within one of the 6 identified reasons of why you can be in executive session. In other words, you don't get to go into executive session, talk about the landscaping contract, and then vote on approving it. That's not an appropriate reason for executive session to begin with, so you shouldn't be in executive session making that decision. So again, I think given the reasons you can go into executive session, that it's still pretty limited what you're going to be able to do in that session. So whenever I talk about this in a class, a real class, in a live class, I get comments, sure enough, from one or two managers and they say, well, there is never a reason for you to make a decision in an executive session. There is never a good reason to do this. And I always disagree with them. And I say, okay, well, then let's look at this situation. We have a homeowner who is suing the association for a lot of money. And that homeowner is sitting out there in the audience right now at this board meeting. And the board needs to make a decision about how much it's going to authorize the attorney to offer to settle this matter. And the board's going to decide, look, start low, but we're willing to go up to 10,000. Is that something we really want to vote on in an open session where that homeowner is listening? Right. You're not going to vote on that in an open session for obvious reasons. That is something you would do in an executive session. So that is a really good example of a situation where making a decision in an executive session is absolutely appropriate and warranted, and you would be doing the association a huge disservice if you tried to make that decision in an open meeting. So there's always reason. And we don't want to make it a practice for everything, but this is a great example of when a decision in executive session is appropriate. So that takes us to minutes. We also get a lot of folks who come to our physical classes indicating that they disagree that minutes can or should be taken in executive session. Now, I don't want to talk about the should part, because I think that's going to be an independent decision. But just remember one thing. Minutes, the only purpose of minutes is to memorialize decisions of the board. That's the true meaning of minutes. Motions made and decisions made. Now, if your board is making a decision in an executive session and you don't have any minutes reflecting that, the first question you should ask yourself is, how will I memorialize this? If that's not in the minutes, what am I going to do so that 3 years down the road, when someone questions what happened, how am I, if I'm still the manager on the board, how am I going to be able to document or at least go back and see what transpired? Because I'm not going to remember in 3 years. So that's one question you should ask yourself. Now, the other thing, before you even answer that, you should know is in 2014, our records laws changed. Kiowa was revised to change the identity of what records are open to inspection to homeowners. And one of the changes was that the association could withhold any executive session records. Okay, so what does that mean? Well, it means if you want to take notes or minutes as to what transpired in an executive session, you can do it as a separate document that's kind of outside the document that just has the regular minutes, okay? And you can have it as a separate document, and that's a document you don't have to provide to homeowners when they ask you for minutes, and it's not one you have to post on the website. So at this point, we do have the capability to take meeting minutes during an executive session and not provide copies to homeowners. But by the same token, if you take minutes, they are an association record, and even though we don't have to provide them to homeowners, if there's ever a lawsuit, they're going to be subject to production in the lawsuit. So if they're out there, somebody could hypothetically still sue the association and ask that they be produced. So which is why you really want to be careful about what you put in your minutes, even though we're not necessarily going to be giving them to anybody. But the answer is yes, you can have minutes in executive session. You don't have to provide them to homeowners. But be careful as to what you put in the minutes. We really only ever want to reflect motions and decisions. All right. All right, let us move on. Okay, and this is something I would really like to take a couple minutes to discuss, because I oftentimes hear executive sessions and working sessions used interchangeably by various individuals, and they are not at all the same thing. So I want to talk about this really quick. Well, maybe not too quick. So an executive session, we just talked about what it is. You guys know what it is. We've discussed it. A working session is a term I often hear boards use when they want to have a meeting or a discussion about a specific item, like maybe it's the budget, maybe it's reviewing some contract bids that came in the door, and they want to be able to talk about these things, but they don't want to do it in a regular meeting. The reason I typically get as to why they don't want to do it in a regular meeting is because it would take too long. We don't want a 5-hour-long meeting. We want to be able to do this outside of a meeting. So at the meeting, we are ready to make a decision in front of the homeowners. And I say, you know, that's legitimate for the most part, but keep in mind, if you're having a working session, it is still technically a meeting. If you look at a definition, just the regular Webster's dictionary, any dictionary, look at the definition of a meeting. It really is just the gathering of people. It's gathering of people. It's not for the purpose of making a decision necessarily. It's not even for the purpose of discussion. It is a very general definition of people getting together. So by that definition, a working session is still going to be considered a meeting. And if you have a working session and you have a homeowner who happens to show up and say, hey, I want to sit in and listen on this, you are going to have to say, okay. All right. So an example might be the board decides we're going to meet 10 a.m. on Saturday at the local Starbucks. We're just going to get some coffee and kind of talk a little bit about kind of what we want to see or what we think about the landscaper and whether we want to make a decision to get other bids. It's legit. So the board is sitting there and they're chatting about this. Meanwhile, Joe, who lives in the community, stops by Starbucks to pick up a coffee. He sees the board. He says, hey, fancy seeing you here. What are you guys doing? And the board says, oh, you know, nothing. We're just talking. And Joe says, okay, can I sit in and listen? The answer is going to be yes. That is the correct answer. Yes, you can. Because this is not an executive session. In other words, you don't get to exclude people. Now, certainly there's no duty to announce you're doing a working session. But if somebody shows up and wants to sit in, yeah, you got to let them. Kind of the other side of this is, I want you guys to think about this from the perspective of an owner who's an involved owner, who cares about the community and goes to every single board meeting. Now, granted, there probably aren't that many of them, but there are some. And if I am one of those homeowners and I go to every meeting every month, and the last month's meeting I went to, I know the manager got 3 bids that she or he distributed to the board. And now I'm showing up a month later and the board, without any further discussion, says, okay, let's vote on approving ABC landscaping contractor today. And they vote on it and nobody's talked about it. Nobody asked any questions and no one's arguing about it. I know, so I'm not completely stupid, I know that there's been some discussion in between these 2 board meetings. And if I know that, I'm going to start making things up in my head as to what those discussions were. And we also all know from experience, I think, that when we have to make up conversations in our head, it's not going anywhere good. And it's usually going to be something like, oh crap, the board is taking my money and running away to Hawaii. And it is going to start the spiral of, I don't trust the board. What are they doing? They're not being transparent. So I'm not saying don't have working sessions. That's not what I'm saying. But what I'm saying is those should be exceptions, not rules. And please have them few and far between, and only if you absolutely need them. And again, should a homeowner show up, make sure the answer is yes, you can sit in. All right. So that's my little soapbox on working sessions and the fact that they're not executive sessions. Oh, maybe I should have made this my first silly picture. It's not a wine bar, it's a webinar. As much as you guys wish it was a wine bar, I think I wish it too. Okay, so with that in mind, we did finally get to the end, and I am going to answer questions now. There's a few of them that have accumulated. And so I'm just going to go through in order and kind of take them. Whoops. Okay, so there's some mention here of an echo. I can't. Okay, there we go. How is a potential buyer who wants to attend a board meeting prior to executing the purchase contract? So I think what you're asking is if someone has not yet legally purchased the unit, but they're planning on it and they want to attend a board meeting, are they entitled to? Well, the answer is if they're not yet an owner, they can't play that card. Okay, so they're not entitled to attend as an owner. And so the only way they would legally be entitled to attend is if the current owner makes them their designated representative in writing and says, hey, this potential purchaser is my designated representative, she can go to the meeting.